Good afternoon, everybody. My name is Paul Singer. I am a partner and chair of the state AG practice here at Kelley Drye, and welcome to our latest state AG webinar, this time with the Minnesota Attorney General's Office. I'm going to give it just a minute for people to log on, and then we will get started with our webinar. So hang tight for just a second. Thanks, everybody. All right, it looks like everyone has joined for now. So I will get us started. Hi again, everybody. Paul Singer and chair of our state AG practice here at Kelley Drye. And just wanted to start with a welcome to this month's webinar, our state AG webinar with the Minnesota Attorney General's Office today. As usual, I am joined by my colleagues on the Kelley Drye side, Abby Stempson, Beth Chun, and Andrea deLorimier, who are all part of our state attorneys general practice here at the firm. And we are really pleased to be joined by several members of the Minnesota AG's office today, James Canaday and Jessica Whitney, who are both co-leads in the consumer protection section, and then Sarah Doktori and Noah Lewellen, who are both part of the privacy unit. And this month, we're going to be talking specifically about consumer protection and data privacy, and in particular, Minnesota's relatively new data privacy law, and what to expect from the office in future enforcement in this space. So just a quick overview of our agenda, and then I'll do a little bit of housekeeping before we get started. As I mentioned, today's topic is data privacy, but for those who have been on our webinar series before, you know that we like to do a little sort of beginning part where we focus in on general consumer protection enforcement in the state. So we're going to have folks speak generally to consumer protection in Minnesota, but then we're also going to do our more traditional lightning round questions where we dig in a little bit on the specific statutory authority that exists in Minnesota in the consumer protection space. Before we get started, though, just a couple of housekeeping things. First, for those that are seeking CLE today, I will be reading out a 4-digit code at some point during the presentation. I will read it twice. Please make note of that code. You'll need to put that code in a form that you'll submit after the fact that will get you CLE credit for today. Like I said, I will read that likely towards the end of today's presentation. Also, if you have questions throughout the course of today's webinar, please use the Q&A feature that you'll find on your screen. We will do our best to try to get to questions and address them today, but in the event that we can't, we always follow up with a blog post where we will try to address any outstanding questions, or you can always reach out to any of us directly and we'll put up contact information towards the end of the presentation as well. So with that, I'm going to pass it off to Abby to get us started today.
All right, so happy to have all of you here. We're going to start with James and Jess to tell us about consumer protection in Minnesota. But first of all, James and Jess, talk about a state with a lot of experience in their consumer protection leadership. James, how long have you been in the office?
I'm at 18 and a half years.
And all in consumer protection?
Yes, started in consumer protection as a line attorney, and then I became a manager and then a deputy about 11 years ago.
Okay, and Jessica, this isn't your first go around in an AG office. You were in Iowa for how many years?
About 18 and a half in Iowa, all in consumer protection.
And how long have you been in Minnesota now?
Over 3 now.
Okay, so a lot of experience that we get to hear from today. So James, Jess, start out by just telling us in general, explain consumer protection in your office.
First, Keith, Attorney General Ellison, please call him Keith, sends his regards. He wishes he could have been here to start and kick us off. He is excited and thankful that you all are interested in Minnesota consumer protection law and welcomes any questions. And if you see him at an event, please reach out to him and let him know you saw this. So that aside, the other disclaimer we always have to give is what we say today are our opinions. Even though I just gave you Keith's greetings, everything else we say is our opinion, so take that with a grain of salt. James and I are going to do the background, and then we've got our data privacy experts to bring us home. James.
Yeah, my quick high-level framing would just be we're certainly a state that cares about consumer protection. We've got a lot of people who work in that area, but we also, not just lawsuits, we're interested in resolving issues. So we have a big team working on that too. We'll probably talk more about our consumer complaint function in the office in a bit, but certainly the entire time I've been in this office, consumer protection has been one of the main focuses.
Great. Jess, any other words before we start talking about our consumer protection lightning round questions?
Just echoing what James said, it's an important part of our office. It has grown in the last several years. There's a reason I got at it, and there's 2 of us, and we're a large section with 8 divisions in our section, a good amount of people. And we do everything from investigations to outreach to education, like we're here today, to legislation and sort of everything in between.
Okay. So our lightning round. Let's start. How is the AG selected in your state?
He's elected. I feel like I need a buzzer to buzz in and to change
Right.
for me who's faster. We'll alternate. He or she is elected every 4 years off cycle. So coming up is the election for AG.
And tell us about how CP is organized. You mentioned you have eight divisions or 8 of something. Tell us about what all is included.
I'll get started and let Jess double check me on this one because we have grown, as she said, and it gets confusing to explain our arrangements at this day and age. So we've got our consumer protection division, which does, consumer fraud and deceptive practices and the first type of consumer protection work that may come to mind. We have antitrust. We've got a charities division. We've got residential utilities division. We have a wage theft division. So that's one of our newer divisions, a group of people specifically focused on wage theft. Civil rights. So likewise, kind of a spinoff of newer priorities within the section. So we have a civil rights division focusing on those issues. And now I turn to Jess and say, what am I forgetting?
We have the folks that answer complaints, which I know is one of your questions later on. So we've got our consumer action division, and then we have a sort of litigation specialization division, library, that serves the whole office, but is centered in consumer, and so should tell you the importance of consumer in what we do. And while we have these divisions, we're not a siloed office. They all work across division lines. Sarah works in antitrust quite a bit here. Noah has helped out in civil rights and wage theft in other divisions as well. So,
okay. And how do you set priorities, especially with all those divisions that you have in consumer protection?
I mean, I think this is a tricky question, and it always changes. It's an art, not a science, and I think that's probably true for most AG's offices. Priorities, what is important, what's harming the most people, and maybe not most people, but maybe it's doing the greatest harm, right? It's not necessarily we've got a lot of complaints on something, but maybe it's really hurting people. It's taking people's homes. It's hurting people's health. Issues like that always rise to the top. Something we see a void or a vacuum in. So these days it's hard to get federal legislation passed, and if the feds aren't going to legislate, like say in data privacy, and the states step in, that's oftentimes where our office will go. What our AG might be focused on, and maybe what our folks have expertise in. I think there are a lot of different factors that go into deciding what our current priorities are. But top of mind is harm done to consumers and protecting the public.
And how about multi-states? Do you participate in them?
Absolutely, enthusiastically. A lot of people have increasingly become aware of kind of the multi-state organization that happens behind the scenes with AG offices, because it's behind the scenes isn't really how it's necessarily always done anymore. A lot of that's very visible. But, for any state, regardless of your size and your resources, multi-states are a cost-effective, like division of labor effective way to work on matters that cross state lines. So in anything that remotely touches Minnesota interests, we're going to be in a multi-state is the general rule.
Thanks, James. And how about, you've mentioned consumer complaints. Let's talk about that. What do you do with those?
Yeah, so I'll take the next two questions and I'll put them into one. We take all consumer complaints. We've got a consumer complaint portal. There's a general complaint form. There are specific complaint forms for some issues. We have an entire division dedicated to handling those consumer complaints. They also answer the phone and will take complaints over the phone. And then when I say handle, that is that complaint resolution rule. They will work on resolving those complaints. They are not lawyers. They are non-lawyers, although they will get lawyers involved if the situation may arise.
Just ballpark it. How many complaints do you guys get in a year?
Oh, James,
I have numbers. I have numbers. I anticipated this. So, I mean, this fluctuates year to year. That's why 5 minutes before we started, I was looking for our most recent numbers. We had 18,000 mediations in, I think this would have been fiscal year 2025. And this was approximately $8 to maybe almost $9 million that we recovered for consumers. So that number is generally entirely outside of lawsuits or actions that we take on the law enforcement side, but just the voluntary mediation process.
And while we're on consumer complaints, and since I see the list of attendees, and many of you are in sort of the business realm and work for various companies, my one piece of advice, and it may seem so glaringly obvious because you all are dialed in, so I'm just going to give you like, good job, you're doing excellent work, and you've got great sort of sense, but is don't ignore the AG complaint and have a mechanism to pull them out, like to know when they're coming into your company, and so that they just don't normally get them flagged in some way, shape, or form. I've had many cases start because companies just didn't handle their consumer complaints, didn't respond, or had them. These days, I would say they were responded to by AI, but this was back in the day, so I don't know who was doing such a bad response, such a pithy response. But when an AG's office that's dedicated to that gets no response or gets a very lacking response, you automatically put a microscope under what your company is doing in that case. So that's my bit of corporate counsel advice. And again, I think you're on this, you're light years ahead of others, but I preach it to those in your company and at other events.
I know we're going quick, but let me echo it with a very quick anecdote. I had a situation where we were doing a mediation process regarding concerns about consumer fraud. We did think there was a consumer fraud problem, but ultimately there was a criminal investigation from the U.S. Attorney's Office. And what ultimately sent somebody to federal prison was lying to us in a response to a consumer mediation request, and in telling our office that we were wrong in investigating for fraud. So there's an additional reason to think about that when you're getting the letters requesting assistance from an AG's office.
Well, thank you, James and Jess. I'm going to pass it off to my colleague Beth, who's going to ask you some more questions in our lightning round.
Thank you. So next, what is your primary consumer protection statute or statutes?
I've lost track of where we are. I'll go quickly on this one. So I already mentioned briefly, but the three primary ones that are involved in a lot of our work are our consumer fraud statute. For anybody who wants numbers, Minnesota statute 325F.69, our false advertising statute 325F.67, and our Deceptive Trade Practices Act 325D.44. So those are the ones that are involved in most of our cases, and then we have a whole host of more specific ones that can become involved.
And we've talked a little bit about some of the ways investigations might get started, but just to confirm, are you able to conduct pre-suit investigations by statute?
Yes, and again, if you want numbers, Minnesota statute 8.31 allows us to do written discovery, interrogatories, document requests, and take sworn statements.
And are those responses confidential? Are the requests confidential under those statutes? or under some other mechanism?
So the process itself is not public, and anything given to us through a CID is not able to be requested by anybody else, so they're confidential in that respect. But we can use that information in law enforcement actions. We can share that information with other law enforcement partners. So I'm answering, it's a little bit nuanced in terms of whether it's just confidential or not. But generally, that's not a public process while an investigation's going on.
Right, thank you. And under the statute, is there a specific mechanism for a party to object or set aside the requests? And is there a specific time frame for that?
Yeah, it is essentially like it is regular discovery. The Minnesota rules of court apply, and you can move for a protective order or, object on scope, etc., quash the deposition testimony, and you follow the Minnesota court rules. They're referenced in 8.31. And timing would be before that response is due. There is no specific time, but ideally you would respond before we went to move to enforce our CID.
Thanks. Yeah, some states do have a specific timing requirement in their statute, so that's helpful to know. And then how do you enforce compliance with the response itself? Is that also the standard rules of discovery?
Yeah, we can likewise go to court to seek an order to compel if there is not an appropriate response to a CID.
Does your consumer statutes, do they have a statute of limitations? And if so, what is it?
For the most common one, 6 years. But as James said, there's a bunch of different statutes, and you would need to check the limitations period on those.
And before you guys would file suit, does the law require a pre-suit notice, and when would that be provided?
No requirement for pre-suit notice.
Okay, and then we have a few more in our lightning round before we get to the privacy section. We'll go through these pretty quickly. What types of settlements can you enter into by statute or otherwise?
By statute, we can do an assurance of discontinuance, and we can also do just a court order if we've sued you and do a consent judgment.
And what's the civil penalty authority?
So for the general consumer statutes, it's $25,000 per violation, and per violation can mean lots of things, as is typical.
Right, and are restitution and disgorgement available?
Yes.
Are there times that you don't seek some of these remedies like injunctive relief or penalties and payment?
Hard to say, kind of on a blanket basis, times where we don't. We're entitled to all of this relief and costs and fees, which we haven't talked about, under the general 8.31 statute. So in most matters, we're going to seek them. I will say in most matters, our highest priorities are restitution for consumers, if that's an issue, and injunctive relief to address the behavior, but the rest of the potential relief comes into play as well.
And do your settlements or provisions in settlements sunset typically?
Generally, no. And I would say traditionally, I would have said never. I think especially as we add injunctive terms that target specific behavior and that sort of are outside the boundaries of the statute, but that you've agreed to, and might have stuff that becomes obsolete or needs to change as the rules change. We've added some in, but if we've just asked you to obey the law, that should never sunset, in theory. So talk to us.
And so then, since sometimes they never sunset, how are you all able to enforce the injunctive terms? And does it make a difference whether they're in an ABC mechanism or not?
So it's always going to depend on the details a little bit here in terms of, what type of conduct we're talking about, how long it's been, if the court specifically retained jurisdiction, or if it's open, closed, etc. But putting that aside, generally it would either be by motion in the matter that was already filed and open. It could be a motion for contempt if we think there's been a violation of a court order. We have had a matter I'm thinking of a specific matter where it was ongoing permanent injunctive provisions and it was many years after the fact. And we simply filed another action, and kind of part of the factual background of why we were bringing that action for a violation of the law included the previous action. So any of those.
Thanks. And now we'll quickly discuss whether you have any specific laws for price gouging or auto renewals.
Sorry. Yes, we have price gouging protections, and I was just trying to find that citation. James, do you have it off the top of your head? Our UNEP statutes also are always going to cover price gouging. So those three that we talked about at the beginning will stand in for price gouging, and we can bring price gouging claims under them.
Price gouging is 325E.80. It's relatively new. I'll just briefly say on that one, we were one of the minority of states that didn't have price gouging specifically. So at the time of the pandemic, we did not have specific authority. We did bring multiple price gouging actions either under executive order authority or general consumer laws, and were successful there. But then after the pandemic, maybe 2023, we did pass specific price gouging law.
And for auto renewals, you all do have an auto renewal statute as well. I
We
believe.
do. We don't. My opinion, I think our auto renewal law is relatively on the weekend, but again, our general consumer laws are kind of added to that, besides just the specific law, and especially with the unfairness provision,
And
we could address it.
I just wanted to add in here, because you're talking price and things like that. We have a price transparency law that just recently passed, and so I think that kind of goes hand in hand with just sort of these issues of laws targeting specific things, but that's all in pricing. Some might call it a junk fee law. So
Thanks. And then as a nice transition, do you have a privacy law? The answer to that is going to be what we talk about for a while. So I'll go ahead and transition this over to Andrea and Paul, who I think are going to lead us into the next section.
Yeah, thanks, Beth.
Go to
So
the next slide,
before,
please. Yeah, thanks.
yeah, before we dive into Minnesota's law specifically, I think it's helpful to take a step back and kind of look at the broader privacy landscape. So as of today, 20 states have enacted comprehensive data privacy statutes, with a few others having privacy statutes that target specific things like children's privacy or biometrics. And that number will only continue to grow as there are a number of other states with pending legislation. So while these laws share a common foundation, sharing things like consumer rights, access, deletion, opt-out, they also share other obligations around notice and purpose limitations. These laws are definitely far from uniform. They vary in scope and applicability thresholds, the type of data covered, and whether certain entities are exempt. And of course, they also differ in terms of enforcement frameworks, particularly around things like cure periods, penalty structures, and the discretion afforded to AGs. So for businesses, as I'm sure our audience knows, compliance is no longer just about, complying with one statute, but instead navigating overlapping and often conflicting statutes. So against that backdrop, Minnesota's Consumer Data Privacy Act will offer some important lessons about how these statutes are being interpreted and enforced in practice. So with that, I'll turn it over to Sarah and Noah to discuss the law in more detail.
Thanks so much. Really happy to do so. So moving on to the next slide. We, as you mentioned, the key provisions of Minnesota's laws are laws similar to those of many other states. There are a number of individual consumer rights and then many obligations that apply to businesses. We will go kind of through them one by one. We'll hit some of the highlights later on, but many of those that you see, right to request deletion, correction, other information about how consumer rights, consumer information is being used and where it's being sold. I know our focus today is on the Attorney General's enforcement, so I just really wanted to hit some high points there. The Attorney General's office has exclusive enforcement authority over this law. And the penalties are really significant in our law. One way to think about it, or a kind of important point to make, is that in order to be subject to the law, you as a controller, you really have to be processing a minimum number of consumers' information. So if you are not processing more than 50,000 consumers' information and meeting all of the other requirements, you're not subject to the law. In many cases that we've seen, when there are violations, they apply kind of across the board. And civil penalties apply $7,500 per violation. Okay, this is kind of the best case scenario. If you have a structural violation, the penalties get really significant really fast. So that's been just a kind of an interesting dynamic as we go about enforcing and really facially being able to show that there's a pretty strong entitlement to substantial civil penalties if we can demonstrate certain types of violations. But that said, our office has been working really closely with entities that have been engaging with us to make sure that people come into violation. It is a new law. It came into effect over the summer. And then just at the end of January, the notice letter requirement expired. So prior to then, you would get a letter if there was a violation, and you had 30 days prior to the time that we could bring an enforcement action to go ahead and address that. We move on to the next slide. So just talking a little bit about how our office has been set up. We have 6 attorneys and 1 investigator who has been really essential because there's a big technical piece to this work, as you may imagine. As Jessica and James covered, we, in many cases, work collaboratively with other states. Privacy is no exception. We are regularly in communication and regularly collaborate with other states where overlap exists. We have a number of public-facing resources that are available both to industry and to consumers, including a data privacy complaint form and rights requests templates that can help people kind of use the right language to decide how which rights they want to enforce, but understand a little bit, translate the statute a little bit to make that more accessible for Minnesotans. And as Noah will cover in a few minutes, Minnesotans have been exercising those rights. We have seen that they have taken the templates offered and used those templates, and we're really pleased to see that. We've also just done a really substantial. Noah was one of the original lawyers on the team, so he took the laboring oar, I'm afraid. But the team overall has done a really substantial amount of outreach, reaching out to speak in a variety of settings to educate both consumers and industry about what the law is, about its central components, and giving people the opportunity to either start to exercise their rights on the consumer side or come into compliance to the extent that they need to do that on the industry side. And we've also really been in communication with entities where we see issues and open for those conversations. Can we move on to the next slide? I'll turn it over to Noah.
Thanks. I can't see the slideshow, so I will trust on faith that we guys are going to the right slide. But I'm going to talk a little bit about some statistics that we've had since we started enforcing the law. We've gotten 200 consumer complaints since July, and those have all been consumer data rights requests or for improper use of data or for data breaches. And so when I say 200 consumer complaints, it's not all rights requests. There's a little bit of this, a little bit of that. We counted some data breach complaints in there. But the takeaway I think that we wanted to come to this presentation and other presentations that we've given is that Minnesotans care deeply about their data privacy. This data, by the way, it's through the beginning of February. So it was about 6 months of complaints following a start on July 31st. They really span the gamut. There's not one through line throughout those complaints. There's something for everyone is what I'd like to say. And for those of you not familiar with state AG practice, or especially, I guess, Minnesota state AG practice, 200 complaints in 6 months is about one law is a very large volume of complaints. And so we'll have more on this later, but It really does show a level of sophistication for the Minnesota consumer, and it reflects state AG outreach efforts, which Sarah briefly touched on. But we had outreach efforts at our very, very large, nation's largest state fair, and a couple of street festivals, and at the legislature and a variety of other places. Sarah and I and other people on the team have done a lot of outreach to and to attorneys like yourself in private practice, and so we've really tried to get the word out. So potential responses that people have gotten from our office or that we would send out during those first 6 months. And I'm going kind of from the top further down in level or the most likely response that you would have gotten had your client or your representative gotten complained about by a consumer. First is a consumer and or industry education. So some complaints your client would have even seen because we took a look at them and we said, this doesn't seem pretty actionable. So we would have reached out to the consumer and done some education on what the law meant for them. An example that I can provide of this is if a consumer came to the AG's office and said, hi, I'd like you to go delete company X's data for me. Obviously, we do not delete company X's data, so we would have had to educate the consumer that they need to create a rights request to that company, and we would have maybe helped them do that using the template forms on our website and sent them on their way. An education letter or education call to a company. This could be any number of things, but sometimes it can be as simple as a company just not accepting consumer complaints from Minnesotans because it wasn't their privacy policy hadn't been updated since August of 25. And so they had some automatic bounce back error that said, you're not a California resident, you're a Minnesota resident, and so none of these rights apply to you. And so sometimes that might result in a call if we could identify a legal officer or someone at the company that we could identify without going through 4 hours of phone tree. Maybe you guys ought to fix this, pretty soon here. The second level that we might do is a mediation. And so Jess and James touched on this earlier, but the office is very comfortable and has a longstanding role of not taking a side when we receive a consumer complaint. It's a standard stance for the office in non-privacy matters, depending on the dispute. But in privacy matters, it's particularly sensitive when we're mediating a dispute when the company is stating, for example, that they can't verify the authenticity of a consumer request. And so we want to approach the company and say, here's what the consumer says. You guys want to take a look at this and get back to us? That would be great. That's kind of the tenor of a mediation letter, where we're not saying one way or the other that they're wrong. And then further down the spectrum, we have a violation letter. These violation or notice or enforcement letters, you might hear us kind of refer to them all kind of the same. These are extremely detailed. I like to describe these as half education, half enforcement, half outreach. And I'll talk more about these in a second. And the last is CIDs. So CIDs are civil investigative demands. These are the less bubbly older brothers of notice letters in which we have to provide a minimally descriptive statement of our reasonable belief for our authority to issue the demand. This is pre-litigation discovery that we were talking about before. We sent a few of these out during the first 6 months. We issued ones where we saw what we believed to be emergent issues that needed immediate addressing, or particularly recalcitrant targets who weren't responding well to a notice letter. More on that later too. All right, let's go to the next slide. All right, you should be looking at a slide that says enforcement letters. And this is an example of the beginning of an enforcement letter. Again, these were sent, and we explained in the letter that they're primarily educational in purpose. We would have specific points of noncompliance. So, we'd say something along the lines of the consumer says X. We looked at your privacy notice, and it appears to say Y, and we think it does not comply with the MCDPA in these very specific subdivisions. So please get your ducks in a row, and also please let us know if you disagree that you're subject to the MCDPA. And we would generally request a 30-day meeting with your representative, or a meeting within 30 days of you or your legal representative to kind of talk through in an informal phone call and provide education and an understanding of where your company was coming from. And these letters are consumer oriented, but not consumer driven. And so what I mean by that is, some of the letters could say, consumer A has complained and wants you to do this thing. But more often than not, when we got a consumer complaint, it would be alleging some systemic issue in the company's privacy process. And so we would be mostly trying to go to the company about that particular systemic issue, not a one-off consumer issue. That's when the enforcement letters would get issued. All right, let's go to the next slide. All right, this is a very non-professional graph that I prepared myself for you fine folks. And it talks about this is how we highlighted the enforcement letters and what industries kind of received the brunt of the AG's focus in the first 6 months. And so before the law became effective, we had a number of calls with various industry stakeholders expressing in so many words concerns that their industry would be uniquely burdened by the new Consumer Data Privacy Act. And so I thought this might be helpful for you and your clients to take a look at and see the kinds of complaints that we got, that we acted on. I do want to say that we acted on because we got a number of complaints that are not reflected in this graph. For example, if we received a complaint about a government agency, which is completely exempt under the MCDPA, it did not make it into the graph. So some not so surprising takeaways, like consumers care about retail. That includes brick and mortar retail experiences and auto dealers, as well as online retailers. You'll see that that is the by and way the furthest and largest group of people that complained to our office that got letters. That's not particularly surprising, as you imagine, but it's probably high interaction with consumers. And so those are the kinds of places that are most likely to receive a rights request. But there are also some surprises, at least to me. You'll see broker takes up about 25% of the enforcement letters we sent out. I was surprised to see how many complaints we got about what one might consider, quote unquote, invisible merchants, those dealing purely in personal data, not with direct interaction with consumers. And I think this is a callback to earlier in the slides when I was talking about the relative sophistication of the complaints that we were getting. As someone who I used to write mediation letters for other areas of the office, and you see all sorts of letters come in to the AG's office, as you might imagine. And I can tell you that the quality and caliber of the privacy notice letters that we were receiving from consumers, this is a dedicated group of individuals who are interested in not only protecting their privacy rights in a sophisticated way, but also there's not a non-zero population in Minnesota who's very interested in testing the boundaries of companies' privacy procedures just on the basis that they can. So you'll see repeat complainants who will write in about different industries every time they find a problem because they feel like they have a receptive ear at the Minnesota AG's office, which they do. I also wanted to highlight in this chart the tiny sliver that's occupied by nonprofit. So Minnesota's law is one of the few that does not broadly exempt nonprofit entities. And we had more than one interaction before the law took effect where we were questioned on why we were bothering to regulate nonprofits. Our answer, by the way, is that you should ask the legislator. And how we would enforce, which, by the way, our answer is like any other industry. But all that sound and fury for this level of complaints. And it's interesting to see that's kind of reflected in this data. And it's good to recall that the SBA, the Small Business Association or Administration, sets small business levels, which are cited in the MCDPA. And the MCDPA largely exempts small businesses except for sales of sensitive data. And a lot of nonprofits have to get quite large before they're considered not small businesses under those SBA rules. So just as an example for museums, classic nonprofit entity, they have to have something like $34 million in annual revenue before they're not a small business. And so a lot of nonprofits are going to find relief in other areas. All right, next slide here.
And Noah, before you jump into the next area, I'm just kind of curious here. You mentioned that this sort of breakdown that you actually submitted enforcement letters, and understanding there's the category that's just completely exempt or wouldn't have received an enforcement letter. Does this roughly track the complaints that you received? Would you say ballpark sort of percentage-wise?
Ballpark, yes. It gets very hairy. Like, for example, insurance is a tiny sliver here. We got a lot of exempt insurance complaints. And so the MCDPA has a number of exceptions, particularly when it comes to healthcare and HIPAA protected data. So, insurance is a small sliver here. I would say health related complaints got pretty high up there. I was talking about sophisticated consumers. Consumers are not necessarily going to understand the edges between HIPAA and the Minnesota Health Records Act and the MCDPA. And so those that's just an example of like where you could see kind of the data get a little bit ugly and fuzzy. But I would say it's very fair to say that half of them were about retail.
And not trying to like put you on the spot or bind you with this question, but I just want to sort of clarify for the audience too that when you see trends like this, especially, I mean, you mentioned you were a little surprised at the data broker volume. Does that change your perspective then in terms of enforcement priorities and where you all may want to concentrate efforts just based on the feedback you're getting from the public?
So I don't want to steal Sarah's thunder where we have a slide called enforcement priorities, but I think it's very fair to say that the agency is consumer complaint driven. And so if we get a number of complaints about a data broker, um, you know, we're going to have a lot of attention on that data broker. So I don't know if it drives overall priorities of the office, but in the sense that a priority of the office is, ongoing investigations or litigation, you could say so.
Got it. Thank you.
Sure. All right, next slide, which I think says early enforcement observations. So by and large, I think that we found that companies are largely cooperative and willing to comply. The MCDPA is, at least from a UDAP litigator's perspective, nice and clear in the sense that you don't have to fight over what is fair or unfair. Generally speaking, when somebody is not processing a data rights request, that seems pretty obvious. And most companies seem appropriately motivated by the $7,500 per systemic penalty to comply and fix their processes. We got a lot of people meeting with us, and generally speaking, people who are willing to make changes to privacy notices or other privacy practices. I have a target-rich environment bullet point here. This was something that we were warned about repeatedly when we first came into our enforcement power at the office, which is that the struggle wouldn't be finding targets, it would be prioritizing targets. And I think by and large, we've found that's very, very true. We've had to focus on not on just finding a violation or noticing something, but dedicating resources in a smart way. Focusing on emergent problems, like I said previously, focusing on problems where the company is not cooperative or willing to comply, or focusing on companies that just simply don't want to respond to the Attorney General's office with a little extra, unless they get a little extra nudge. So it's been an interesting change from normal, I think, and it really has forced us to kind of refine our intake processes. The last bullet point I have here is that compliance requires technical expertise and verification. And I put this on here right before I gave my last presentation because we had an instance where we were investigating a company and that company represented to us that they had fixed the problem and clapped their hands and walked away. And we did a test on the back end and they had not fixed the problem, at least not entirely. And so we went back to them and, after writing a nice but nasty gram saying, it doesn't look like you've actually solved this issue. And as it turns out, there was a highly technical issue with that their internal processes were not able to, change without external help, basically. And they ended up having to work through a third party and get an expert report done and justify to us why they had, lied to us in a communication about fixing these issues. And I say lie. I mean, I fully believe that the company attempted to make the fix and failed to do so because it was unable to or did not comprehend the full extent of the problem. But, we as attorneys are often used to being able to look at something and say, yes, it's changed, or no, it hasn't changed, or yes, this is bad, or no, it isn't bad. And I think privacy is in particular an industry or topic where you really need to rely on technologists and people with other expertise to go in and ensure that you're compliant. And I think I'll switch back to Sarah here.
So before we jump to the next area too, I guess going back to transitioning out of this time period for the notice letter requirement, are notice letters just kind of off the table now, or do you all envision still utilizing those as one potential method to do some of that initial outreach with parties that you find to be in non-compliance?
It's never not going to be a tool in the toolbox. We've certainly used notice letters like this before in UDAP cases, deceptive trade practice cases. They're rare, right? And the fact that we had a requirement of notifying certainly made the tool more attractive to use during the safe harbor period or notice period. But I would, never say never. I think the goal of the statute and with all statutes that we enforce, one of the primary goals is to get good behavior, not to take somebody by surprise and ambush them.
Thank you.
So looking ahead, focus areas. But before we jump in, I just wanted to apologize and correct myself. There had been some pending legislation that was floating around in my head, and I misspoke. The law applies to entities that control or process 100,000, not 50,000 consumers' personal data without the exclusions, excluding publicly available information, so personal data, appropriate exclusions, but 100,000. Or there's another mechanism related to percentage of revenue with a smaller threshold. But we certainly want to be accurate about when the law does apply. And then you would determine, depending on your role, how it applies to your company if you are business side. But looking ahead and thinking about how we are enforcing it, kind of high level guiding principles wise, right? Noah is completely right to say that this is a target rich environment, and basically almost every entity we've looked at, there have been violations, including violations that could ultimately result in big penalties. But we can't, we're focused on areas where there's real harm, and we think about that in a few ways, right? So certainly violations related to sensitive data. And I want to flag that when we say sensitive data, we mean sensitive data as defined in Minnesota statute. We've heard companies and entities use the phrase sensitive data, thinking about the manner in which FTC has defined kind of sensitive locations related to data, but sensitive data is a defined term in Minnesota statute. That's how we use it. So we're really, that's one area of focus. We're also really focused on things like the universal opt-out mechanism that reflect kind of structural mechanisms through which consumers can vindicate the rights that they are afforded under this new law. So as it's pretty burdensome for a consumer to reach out and request, each data broker or company that they interact with correct or delete or do not store their data. Universal opt-out mechanisms are a technical tool they can install and have those signals sent that really makes it reasonable, right, for consumers to do that. And so when those signals are not being honored as they are required to be by Minnesota law, we take that quite seriously because we view it as like a structural impediment to making this meaningful and making there a kind of reasonable avenue to actually vindicate those consumer rights. Speaking of, we also focus a lot on consumer rights requests, as Noah's covered. When we hear from a lot of people, we do, we care about when we're hearing about certain entities not complying with requirements. And then, we look at things that we can see, right? So jumping a little bit ahead, but keeps on the slide for now. Consumers may not read your privacy policies, but we do. We take very close looks at them. And so we care about whether the requirements of our law with respect to privacy policies are being met and whether they're, clear enough about what's actually happening and whether that's consonant with what we learn through reporting, consumer complaints, or otherwise. So we are really thinking about broadly, really it's going back to kind of what Jess was saying at the very beginning, right? There are a lot of different ways to think about harm to consumers. So we are thinking about areas that harm a lot of people, right? Are like a structural impediment, as I was saying with the universal opt-out mechanisms, we view as like that's kind of a broad harm. If you are not structurally complying and responding, then we view that as a pretty broad harm. Or areas that we consider like big harms, right? So processing certain types of sensitive data like geolocation data, other types of sensitive data, sensitive health data, misusing data like that or processing it, storing it without the appropriate consents, which are pretty significant affirmative consent requirements. Those are things that we take really seriously. And that's how we've been trying to kind of focus our time and enforcement energy. So should we move on to the next slide on what this means for your business?
Yeah, and Sarah, would you say that those priorities and focus areas generally align with sort of what you hear from your sister states? I mean, I can tell you just anecdotally, like conversations we've had, it seems like it does. And I think that's consistent with what you were saying earlier about just the open lines of communication and sort of, not necessarily joint efforts but really sort of collegial collaboration that happens among the states and might help the states to stay aligned in that way.
I'd say at a high level, yes, right? I think a lot of states think similarly about harms that are affecting a lot of their consumers, or kind of really significant and harms that we think people would be very concerned about. It's really kind of related to the sensitive data, though there are differences, and obviously, you see different consumers being affected, right? Like the certain entities might be trafficking in Minnesota's data that are not trafficking in Connecticut's or Colorado's, et cetera. So certainly, some opportunities for kind of multi-state work. But I think generally that's right, that the high level view of harm is something that we hear from other states as well. So what does this mean for your business? I can share my bullet points. I wonder if the slide that I'm looking at got into this. If you would flip forward, I can tell you whether I'm sharing my bullet points or they didn't. Nope. All right, let's go back. So what this means for your business, we're shifting now, as we've explained, from education to enforcement. And that doesn't mean that we're not going to be continuing to work collaboratively and kind of meaningfully with entities that engage with us, right, to reach reasonable resolutions. But there has been a lot of education, and the law has been in effect for some time. And so now our expectation is that entities are in compliance. And so you are more likely to get an enforcement letter and more likely to get a CID than you were several months ago. Businesses should really be doing the work now to assess their data privacy practices, and they should be operationalizing what responses look like. If you are not, if you are implicated by the law as either a controller or a processor, and you are not complying with the requirements based on your role that are set forth specifically in the statute, for instance, if you are not responding to consumer requests as required, we would find that concerning at this point, because the expectation is that those should really have come into effect. I think we're getting short on time, so I'll kind of quickly say again, things that we focus on there are specific requirements as to privacy notices. We would expect companies to have reviewed those and updated them to reflect the requirements of Minnesota's law. And we expect entities to be compliant with other requirements, such as respecting the universal opt-out mechanism and having a structure in place to respond to consumer complaints. And let's skip ahead then.
Yeah, and I just want to kind of highlight kind of the issues with tips for business and resolving cases like this. We talked about a $7,500 per penalty, and we also talked about a minimum 100,000 consumer threshold. I mean, a lot of companies that deal with large levels of data are handling 1 million plus consumers. And so if your company wants a six-figure settlement in this space and they have a systemic issue with 1 million consumers data, you're asking the state to find that those errors or violations are worth less than $1 per violation. And of the $7,500 per violation cap that the state is statutorily entitled to. It's just math to remember as you do the math and you go back to your clients and remind them the cost of compliance versus the cost of potential non-compliance. All right, so tips for responding to regulatory inquiries. So I will also try to be swift. I know we want to leave some time for additional questions, but just good to remember that the early stages of an investigation are not formal accusations. I want to circle back on what Paul asked here. are you going to still send out notice letters? And I said they're going to be rare. It's not going to be any much change is that we still have informal outreach. And so if you get an email or a phone call from the AG's office, that's your opportunity to reach out to us. You're not on the record, quote unquote, yet, right? We're not asking you for a written response via formal letter. We're not asking for verified answers. We're asking you to talk to us so we understand what's going on before we hastily pull the trigger and give you guys a massive CID to respond to. So do respond to that. Be responsive and forthcoming as possible. This is straightforward. You guys are smart people. Don't not respond to a government inquiry. It's bad news bears. You guys know what happens after that. We got one tool, and you guys start to look like a nail when you don't respond to an email. And the last one is show compliance efforts. And the tip there is to become compliant without forcing us to go to court and get a temporary restraining order. That goes a long way in potentially relieving the burden of discovery too. If we know that you've solved a problem before it's really gotten off the ground in our investigation, it makes us feel like we can reduce the scope of our discovery because there's less for us to try and figure out if you're telling us that it's fixed or at least partially fixed. The flip side of that is, there's still going to be some things that we're still going to want. And so just because you've become compliant doesn't mean that you don't have to produce data moving forward. And so just be aware of that. And stonewalling significantly increases the likelihood of us wanting to move to compel. And with that bright, cheery note, happy to answer any questions y'all have.
Since we have a couple minutes, I do want to pick up on sort of this last theme of tips for responses here, because Noah, you kind of hit on a few points that I candidly I think struggles for companies sometimes of how forthcoming, cooperative should they be? How quickly should they move to address something, or does that get perceived as an admission that they were in violation or did something wrong, right? I think one of the things we routinely encourage our clients is to have that kind of open dialogue with AG offices generally and maintain sort of a positive dynamic with them so that should there be any issues, it can be that kind of informal outreach. You know who to go to, they're going to be responsive, that they'll make those changes. It doesn't guarantee that it's going to avoid enforcement, but it is, I think, an effective mechanism to help cut to the chase of like, what is it that you all are looking for? What are your concerns and how can we best address them? I guess any thoughts y'all or James or Jess for that matter that y'all can share just generally about sort of your view on sort of the pros and cons of having a more proactive dialogue with the state in general when you are trying to lay that foundation.
My 2 cents is you kind of have limited options at that point. I mean, you can't focus on the I would rather say nothing option at this point for a favorable outcome. Kind of just I'll echo what Noah just said over the last couple of minutes that, it's going to affect how we see things. It's going to affect most likely the scope of discovery you're asked to provide or questions you're asked to answer. But it's very unlikely that we're going to be willing to just accept nothing.
But we will be reasonable. So be honest with us. Be forthright. If we're asking for the moon and the sun, tell us that. We sometimes don't know. We do our best. We don't want to review that many documents either. And be forthright with us in a respectful manner. Don't just move to quash. Like, get on the phone with us, get good counsel that, will work with us, and don't engage. And we are more than happy to listen, to have you point us in directions where you think relevant information will be. Yeah, just engage in that respectful conversation and don't assume we know. I guess we do our best, but we are ignorant of your internal systems.
And I would just harken back to what James said earlier about, I wouldn't call these enforcement priorities per se, or that it's a policy per se, but, he did say, look, we want to make sure that bad conduct stops, and we want to restitute consumers that were harmed. Okay, and then also there's penalties and fees, right? And, if you've stopped the bad conduct, and restitution is very difficult to ascertain in a case where it's, a universal opt-out mechanism, right? And Disgorgement may be a different story, but come to that later. Then you can see why it can be advantageous to solve the problems earlier rather than later.
Yeah, that's all very helpful. And I think that's a more positive way for us to, I think, wrap it up than Noah was leaving us with. So we have hit time. I just want to, again, extend a big thank you to all of our speakers today from the Minnesota AG's office. I think this was a great discussion and very helpful information for all of us. Obviously, our contact information's here if you need to get in touch with any of us. And a quick plug, if you are not a subscriber to our AG newsletter, the AG Chronicles, you can visit this link and sign up today. We give a monthly analysis of just kind of what's happening in the AG space and some major initiatives from AG offices. So with that, one more thank you to all of you, and we will sign off on today's webinar. Thank you, guys.
Thank you.